The ghost appeared on a Tuesday evening in February, and I will tell you immediately what the ghost was. My son had arranged for a woman to walk past the window of my sitting room at precisely 8:15, wearing a white garment, carrying a light garment, carrying a light that was angled to cast shadows upward across her face. The effect, for someone who did not know it was coming, and who was not a former professor of forensic and clinical psychology, who had spent 30 years studying the mechanics of perception, fear, and manipulated experience, would have been alarming. I had known it was coming. Not the specific form of it, not the white garment, and the upward angled light at 8:15 on a Tuesday in February. I had known the shape of it, which is a different and more fundamental knowledge. I had known for 3 weeks, from the accumulation of evidence that I had been gathering with the patient, systematic attention of someone who has spent her professional life understanding how people arrange reality for other people, that my son, Marcus, and his wife Claudia were engaged in something that required me to appear mentally unreliable. The something, as I had constructed it from 3 weeks of observation, was the guardianship petition they were planning to file in the county court. The petition would argue that I, at 74 years old, and following the minor cognitive testing irregularities that my physician had noted in my last annual review, was no longer competent to manage my own affairs and required a guardian. The guardian they intended to propose was Claudia, who would thereby acquire legal authority over my finances, my property, and my living arrangements. The ghost was the supporting evidence they were building. A woman who panics at shadows, who calls her son at midnight because she has seen something alarming outside the window, who reports disturbances and distress. Such a woman's physician notes about cognitive testing irregularities take on a different character. She is not a woman with age-appropriate variation in processing speed. She is a woman whose perception of reality is unreliable. I had recognized the pattern when the first element appeared 3 weeks earlier. The pattern is called gaslighting, the systematic manipulation of another person's perception of reality, named after the 1944 film in which a husband dims the gaslights in his wife's house and then denies that they have changed, designed to make the person doubt their own perceptions. The technique is documented, studied, and identifiable to anyone trained in the psychology of interpersonal manipulation. I had written a chapter about it in the Handbook of Forensic Psychology that my department had used as a standard text for 12 years. Recognizing it did not make it less unpleasant to experience. This is one of the things I have always told students. Clinical knowledge of a phenomenon does not protect you from the phenomenon. You can understand depression completely and still be depressed. You can understand grief completely and still be incapacitated by it. You can understand gaslighting completely and still feel, in the moments when it is applied skillfully, the specific disorientation of someone whose reality is being systematically contested. Marcus and Claudia were not applying it skillfully. This was the relevant assessment. When the woman walked past the window at 8:15, I put down my book. I looked at the window. I arranged my face in the expression of someone who is disturbed by what she has seen. I sat for a moment with my hands clasped in my lap, and then I went to the phone, and I called Marcus. "There's someone outside the window," I said, in the voice I use when I am producing the response the situation is being designed to produce. "A woman. In white. Marcus, I don't know if I'm seeing things, but Mom," he said. He said it with the warmth that is manufactured rather than genuine. The warmth that reads correctly in a recording if you have heard it 100 times, and that reads slightly off in the room with the person producing it. I'm sure it was just a passerby. It's dark. Things can look strange. "Do you want me to come over?" Yes, I said. "Yes, I think I'd feel better if you did." "I'll be there in 20 minutes, he said. I thanked him, and I put down the phone, and I went to the small recorder on the bookshelf, and I confirmed that it was running. "My name is Dr. Vivian Grace Okafor Sterling. I'm 74 years old. I was a professor of clinical and forensic psychology at the University of Michigan for 22 years, and before that, I was a practicing clinical psychologist for 18 years, And in total, I have spent 40 years studying what happens inside people's minds and between people's minds when the truth is not being told. Marcus arrived in 18 minutes, which told me the 20-minute estimate had been a performance. I want to explain gaslighting precisely before I explain what I did about it, because precise explanation is what my professional life has been organized around, and because the phenomenon requires more precision than popular accounts of it typically provide. Gaslighting, as a clinical and forensic concept, describes a pattern of behavior in which one person systematically manipulates another's perception of reality for the purpose of causing the target to doubt their own experiences, memories, and sanity. The term entered popular usage from the theatrical and film versions of Patrick Hamilton's 1938 play, but the behavior it describes is ancient and was documented in clinical literature long before Hamilton gave it a name. The pattern has consistent elements that make it identifiable to a trained observer. The first is the introduction of false information. Events that the perpetrator claims happen differently from how the target recalls them. Objects that are moved and then denied to have been moved. Statements that are made and then denied. The second is the systematic undermining of the target's credibility. The perpetrator builds a narrative about the target's unreliability, their forgetfulness, their history of confusion, that contextualizes the false information as the target's false information as the target's misperception rather than the perpetrator's manipulation. The third is the isolation of the target from people who might confirm their reality. The gradual reduction of outside input that could contradict the perpetrator's narrative. The fourth is the emotional management of the target, expressions of concern for the target's well-being that serve to make the manipulation appear as care. The 3 weeks before the ghost had contained all four elements. Marcus and Claudia had reminded me of things I had said or done that I had no memory of, not because I had forgotten them, but because they had not occurred. They had noticed that I had been confused about several things and had mentioned it to my doctor out of concern. The friends and neighbors who formed my social support had been visited by Marcus with expressions of worry about my mental state. In conversations I became aware of through the embarrassed apologies of those friends when they called me in the subsequent days, I had documented everything. The documentation habit is one I developed in my clinical practice and maintained in my academic work. When something is happening that may later become important, you write it down. I had been writing things down for 3 weeks in the small notebook I keep in my jacket pocket with dates and times and specific details. A psychologist's field notes applied to my own household. The documentation had two purposes. The first was to create a record that could be used if the guardianship petition proceeded to litigation, which I expected it would. The second was to keep myself oriented to what was real. One of the documented effects of sustained gaslighting is the erosion of the target's confidence in their own memory and perception, which the perpetrators in a successful gaslighting campaign exploit. The documentation was the anchor. I had written it down when I was certain of it, and the written record was not susceptible to the doubt that the perpetrators were trying to introduce. The cognitive testing irregularities that my physician had noted were genuine. I want to be honest about this, because honest self-assessment is one of the things I have always demanded of my students and of myself. My processing speed on certain time tasks had declined relative to my performance on the same tasks 5 years earlier, and this decline was age-consistent and clinically unremarkable. My physician had noted it and had not recommended any intervention. I was not cognitively impaired. I was 74 years old. Marcus and Claudia knew about the testing irregularities because Marcus had accompanied me to the appointment, ostensibly as support, actually as information gathering, and had been present when the physician mentioned the results. The results in the physician's framing were a reassurance. Age consistent. Nothing to worry about. In Marcus and Claudia's framing, they became the foundation of a narrative. I had understood this within a week of the appointment. The understanding had produced the documentation. The documentation had produced the recording device. The recorder is a small device, approximately the size of a deck of playing cards, which I purchased at an electronics store in Ann Arbor. It records continuously when activated and has a battery life of 16 hours. The audio quality is not professional. It is a consumer device, but it is sufficient for the purpose of capturing conversation in a room, which is what I needed it for. I placed it on the second shelf of the bookshelf, behind the copy of Kahneman's Thinking, Fast and Slow, that I keep there because it is a book I recommend to students, and because its spine is visible from any position in the room, and because it is wide enough to shelter the device without concealing it from anyone who looked carefully. The decision to use something that was sheltered rather than entirely concealed was deliberate. I am not an investigator, and I had no intention of constructing a covert surveillance apparatus. The recorder was in plain view for anyone who chose to look. Marcus and Claudia chose not to look. The legal question of recording in my own home is straightforward in Michigan, which is a one-party consent state. A party to a conversation may record that conversation without informing the other parties. I was, in every conversation that took place in my sitting room, a party to the conversation. The recordings were legal. I want to address a question that will occur to a thoughtful reader. Was I manufacturing evidence? The answer is no, and the distinction is important. Manufacturing evidence means creating a false record, arranging for things to happen that did not happen, or representing things as happening differently from how they actually happened. What I did was create the conditions that allowed an honest record of what Marcus and Claudia were actually doing and actually saying to be captured. I did not script what they would say. I did not lead them to say things they did not mean. I created a situation in which they were comfortable saying in my presence the things they said to each other when they believed I was not a fully competent observer. What they said was what they meant. The recorder had been in place for 11 days before the night of the ghost. In those 11 days, it had captured several conversations. The conversations were useful in establishing the pattern and the intent, but they were not the complete picture. I needed Marcus and Claudia to speak specifically about the plan, to name what they were doing and why, rather than to be captured in the general pattern of manipulation, which, while damning, was ambiguous enough to be argued around. The night of the ghost, I believed, would be the occasion for the specific statement. I had been right that they would attempt something dramatic, the escalation of the gaslighting to a more overt and documentable form. And I had been prepared. What I needed now was Marcus's arrival and the conversation that would follow. I came to psychology through the law. This is a less common path than most, but it is mine. I completed a law degree at Howard University in 1972, worked for 3 years in a public defender's office in Detroit, and discovered in those 3 years that the legal questions I found most compelling were not about the rules, but about the people. About what had happened in a person's mind in the moment of the crime, about what the law meant when it said intent, and how intent was actually formed, and what factors influenced the forming. The public defender's office sent me in 1975 to a forensic psychiatrist named Dr. James Oze. No relation to my subsequent marriage to Samuel Okafor, though the coincidence of African surnames produced a great deal of confusion across the years. Who was doing evaluations for the court and who needed a legal analyst to help him navigate the intersection of the clinical findings and the legal standards. Dr. Oze was the person who told me I should be studying psychology rather than practicing law. He said it after watching me spend 2 hours with a client who had been referred for evaluation and who had told me in those 2 hours more about the structure of his thinking than he had told 3 previous evaluators in much longer sessions. Dr. Oze said, "You are doing clinical psychology without knowing that's what it is. You should learn what it is." I enrolled in a doctoral program in clinical psychology at Michigan in 1976. The program had a forensic specialization that allowed me to bring the legal background forward rather than leaving it behind, which was the right structure for what I was trying to do. I finished the doctorate in 1981. At 31, with a dissertation on the reliability of confessions obtained under various conditions of cognitive stress, which is to say, a dissertation about the relationship between psychological manipulation and the truth of what people say, The 31 years of clinical practice and academic career that followed had two organizing themes. The first was forensic psychology, the application of psychological understanding to legal contexts, which included the evaluation of criminal defendants, the assessment of witness credibility, the consultation to legal teams on the psychological and actors in evidence. The second was what I eventually named in the textbook chapter and in two articles, interpersonal reality construction, the ways in which people create shared realities, and the ways in which those shared realities can be manipulated by parties with specific interests. The gaslighting chapter in the Forensic Psychology Handbook was the most direct application of the second theme to the forensic context. I had seen gaslighting in case after case, in domestic violence situations, in custody disputes, and elder abuse cases, and I had developed a framework for identifying it, documenting it, and presenting it in legal proceeding. The framework involved the identification of the four elements I described earlier, and the documentation of their occurrence over time, which was what distinguished gaslighting from ordinary interpersonal disagreement. What I had not anticipated, writing the chapter in 2008, was that I would eventually be applying the framework to my own household. Samuel had died in 2019. We had been married for 38 years, and the marriage had been the kind that I have spent 40 years studying from the outside. Genuinely functional, organized around the well-being of both parties, capable of sustaining difficulty without the phase, difficulty destroying the organizing principle. When Samuel died, an aneurysm quickened without warning. The household reorganized around his absence in the specific way of households that have lost their second organizing principle. Marcus was 51. He and Claudia had married in 2005. They had 2 children of their own and a life in a suburb of Detroit that was financially comfortable and that had the specific texture of a life organized around maintaining that comfort. The guardianship plan, I had concluded from the 3 weeks of observation, was related to the house. The Ann Arbor house, which Samuel and I had owned since 1984, and which had appreciated to a current value of approximately $800,000, was the estate asset that Marcus and Claudia were primarily interested in controlling. My monthly pension and investment income were also relevant, but the house was the center. This was the motive. The opportunity was the physician's note about the cognitive testing irregularities. I had documented all 3. Marcus arrived at 8:33. 18 minutes, as I noted, not the stated 20. He came in with the warmth that he had been producing across 3 weeks of the manipulation campaign. The concerned son warmth slightly overdone for the situation, which would read correctly on a recording to someone who had not heard it 100 times. He sat in the chair across from me. Claudia had not come with him, which was the first interesting choice of the evening. She would come later, I expected. Or she would call, creating another element of the documentation. I sat in the position I had chosen for this conversation, the chair that put my back to the bookshelf, which meant Marcus was facing the bookshelf, and specifically facing the Kahneman book and the recorder sheltered behind it. This was not an accident. Marcus said, "You sounded really shaken on the phone, Mom. Tell me what you saw." I told him in the voice I had been producing, the voice of someone who is uncertain of her own perceptions, who is frightened, who is looking to the person across from her for confirmation what is real. The voice took professional skill to produce. I have spent 40 years developing that kind of professional skill. I want to explain something about what I was doing because the explanation requires more care than a simple description of the technique I used. There is a technique in therapeutic context called motivational interviewing, a method developed by William Miller and Stephen Rolnick in the 1980s for helping people move through ambivalence about change. One of the core mechanisms of motivational interviewing is the use of specific kinds of questions and reflections that invite the client to articulate their own motivations and concerns rather than having those motivations and concerns identified for them by the therapist. The technique is effective because people believe what they say more than what they are told, and because the act of articulating something causes it to become more cognitively accessible. more central to the person's awareness than it was before. The articulation. What I was doing was related to motivational interviewing in its mechanism, but different in its purpose. I was not trying to help Marcus through ambivalence. I was trying to make the structure of what he and Claudia were doing more salient to him, to bring the plan into the foreground of his awareness by asking questions that required him to engage with it consciously rather than automatically. When people engage with something consciously, they are more likely to speak about it directly. When they speak about it directly, the recording captures what they say. The questions I used were not leading questions. They were not manipulative in the legal sense. They did not suggest an answer. They did not use language that would contaminate the response. They were genuinely open questions, the kind that good clinical interviewers learn to ask. Questions that create space for the other person to fill with whatever is most prominent in their thinking. "I've been so confused lately," I said in the uncertain voice. "I keep thinking, Marcus, do you think there's something wrong with me? Something real? I feel like I can't trust my own mind." This is a question that, if Marcus were a genuinely concerned son, would produce reassurance. And he did produce reassurance, the appropriate words of comfort and concern. But the question also activated the plan that was most prominent in his thinking, because it named what the plan was designed to produce: a mother who cannot trust her own mind. I watched his face as he responded. The slight hesitation, a fraction of a second, imperceptible to a non-trained observer, that preceded the reassurance. The words that followed were the words of the plan. Almost exactly. The term verbal hypnosis in the story's prompt is not a term I would use professionally, and I want to be honest about what I actually did rather than allow an inaccurate term to obscure the reality. What I used was a combination of established clinical interviewing techniques applied in a novel context. The core technique was the use of open reflective questions that invited Marcus to engage with the structure of his own thinking and to articulate things that he was operating on automatically rather than consciously. There is a principle in cognitive psychology called the saying is believing effect, documented by social psychologists Joel Cooper and Russell Fazio, among others. When people verbalize a position, they tend to become more committed to it and more likely to act in accordance with it. The mechanism is related to cognitive dissonance. The articulation of a position creates consistency pressure that aligns subsequent thoughts and behavior with the position as articulated. I was using the inverse of this effect. I was creating conversational conditions in which Marcus's articulation of the plan in vague or euphemistic terms produced pressure toward more specific articulation. Each specific articulation created the need for coherent elaboration. The elaboration captured on the recorder was what I needed. I also used a technique called strategic ambiguity, in which the interviewer introduces language that is ambiguous between two interpretations, one innocent and one incriminating, and allows the respondent to choose which interpretation to choose, which interpretation to engage with. The choice itself and the way the person engages with the chosen interpretation is informative. The conversation with Marcus on Tuesday evening proceeded across approximately 40 minutes. I produced across those 40 minutes the uncertain, frightened mother performance that the situation had been designed to produce, while simultaneously asking the questions that invited Marcus to elaborate on what was happening and why. Claudia arrived at 9:15. She had been in the car outside. I had seen the headlights pull up at 9:10, which told me the delay was deliberate, and that she and Marcus had planned to have the first portion of the conversation without her. When she came in, the conversation shifted. What had been Marcus performing concern for his mother became the two of them together, which changed the dynamic. With two people rather than one, there is a different kind of cognitive pressure. Two people who share a plan and who are in the presence of a person they believe cannot perceive their plan accurately will, in my experience, be less careful than one person alone. The presence of the co-conspirator creates a sense of mutual confirmation. We know she doesn't. That relaxes the vigilance that individual performance requires. Marcus and Claudia were less careful than Marcus had been alone. The specific statement I needed came at 9:47. It was not a single dramatic confession. Real conversations rarely produce dramatic confessions. It was an accumulation. Marcus saying that when we have the legal arrangement in place, the house would be managed properly. Claudia saying that the evaluation will show what it needs to show, and that the doctor already has the right impression. Marcus saying she doesn't know what we're planning, and Claudia saying she can't know, she's not. And stopping herself, but having said enough. And then the two of them, in the specific relief of a conversation with each other and each other. Presence of someone they had decided could not fully hear them, saying several things that were individually ambiguous and cumulatively unambiguous. I sat with my hands clasped in my lap and the uncertain voice, occasionally asking the questions that invited elaboration. The recorder ran until 11. After they left, I sat for a few minutes. Then I went to the bookshelf and I stopped the recorder. I played back the section from 9:45 to 10:30. I listened to it twice. It was sufficient. The documentation I had assembled across 3 weeks and 11 days of recording was, when I spread it across my dining room table the following Wednesday, substantial. The field notebook, 43 pages of dated, timed, specific observations. The movement of objects that I had not moved, with my notation of the original position and the changed position. The remindings of events that had not occurred, with the specific phrasing Marcus or Claudia had used, and my immediate notation that the event had not occurred. The social engineering, the visits to neighbors and friends, reconstructed from my subsequent conversations with those neighbors and friends, some of whom had been disturbed enough by Marcus's narrative about my deterioration that they had called me to check the recordings. 11 days of continuous capture from the sitting room device, the relevant sections time-stamped and noted in a listening log that I had kept as I reviewed the recordings each morning. The relevant sections were in total approximately 4 hours of audio from an 11-day archive of roughly 160 hours. The documentary evidence, the records from Marcus's visit to my physician's appointment, which I had requested from the physician's office, my records, my right to request, and which showed that Marcus had attended the appointment. The physician's notes from that appointment, also my records, which showed what the physician had said about the cognitive testing. The contrast between the physician's actual framing, age-consistent, unremarkable, and Marcus's subsequent characterizations of my deteriorating condition to the neighbors and friends. I called my attorney on Thursday morning. Not the attorney who handles wills and property, who I have used for those purposes for years, an attorney whose practice specializes in elder law and guardianship matters, whose name I had obtained from a colleague's recommendation 2 weeks earlier, when I had first understood where this was going. Her name was Patricia Mbeki. She was 56 years old, and she had the specific quality that the best attorneys in contested matters have: the ability to assess a situation exactly as it is rather than as the most favorable possible version of it, combined with the ability to identify what the evidence actually supports versus what it is being argued to support. I told her the situation. I told her the documentation I had. She said, "Come in today." I brought everything to her office. She spent 4 hours with me, reviewing the field notebook, listening to the relevant portions of the recordings, with the listening log as a guide, reading the physician's records. She said, at the end of the 4 hours, "This is extraordinary documentation for a guardianship defense. Most people in your situation come to me after the petition has been filed, with nothing but their own memory and their word." I was a professor of forensic psychology for 22 years, I said. Documentation was the discipline. She said, "The recordings are the most significant element. The statements captured, the evaluation will show what it needs to show. That she doesn't know what we're planning, when we have the legal arrangement in place. These are, in context, strong evidence of intentional misrepresentation for the purpose of a fraudulent guardianship petition." What does strong evidence mean in this context? I said. It means, she said, that when this goes in front of a judge, your son and daughter-in-law will have a very difficult time explaining what they meant by those statements in a way that is consistent with innocent intent. And my petition? To have the attempt documented and the proposed guardianship denied. More than enough, she said. We'll file a proactive declaration, a motion requesting that the court note the attempted manipulation and establish a formal record that no guardianship based on these events would be appropriate. We'll also file a separate complaint with the County Adult Protective Services, given the evidence of an intentional attempt to have a competent adult declared incompetent for financial gain. I nodded. What should I do between now and the filing? Keep the recorder running, she said, and stop performing the confusion. You don't need to perform it anymore. We have what we need, and continuing the performance could complicate things. Understood, I said. I want to tell you about the conversation I chose not to have, because choosing not to have it was one of the most difficult things I did across the period, and because the difficulty deserves acknowledgement. My son is 51 years old. I have known him for 51 years, which is a longer and more complex knowledge than any other knowledge I have of any person. I know the child he was, and the adolescent he was, and the young adult he was, and the middle-aged man he is now. I know his strengths, which are real. He is hardworking and loyal to the people he decides to be loyal to, and genuinely good at the technical dimensions of the financial work he does. I know his weaknesses, which are also real. The specific susceptibility to the influence of the person closest to him, which has been present since childhood and which produced, in combination with Claudia's organizational intelligence and her capacity to persuade Marcus that her interests and his were identical, the situation I found myself in. I believe, and this is a clinical assessment as much as a maternal one, that Marcus had not initially planned the guardianship. I believe that Claudia had identified the opportunity and had constructed the narrative and had gradually moved Marcus into the plan in the way that people are moved into things that they would not initially choose. Incrementally, with each step presented as a logical consequence of the previous one, until the person is somewhere they would not have agreed to go, if shown the destination at the start. This does not exculpate Marcus. An adult who allows himself to be moved into doing harm to his mother, step by step, is responsible for the harm even if he did not initiate it. But it is the full account, and I have always believed in the full account. The conversation I chose not to have was the confrontation. The direct address of what I had observed and documented. The presentation of the evidence to Marcus before the legal proceedings began. The opportunity for him to recognize what he had done and to remove himself from the plan before the consequences became formal. Patricia had advised against this conversation. She had said, correctly, from the legal standpoint, that a direct confrontation would alert Marcus and Claudia to the existence of the documentation, would allow them to modify their behavior, and might produce actions that would complicate the legal picture. But the reason I chose not to have the conversation was not entirely Patricia's advice. It was something more personal and more difficult. If I confronted Marcus directly, the confrontation would produce one of two outcomes. Either he would recognize what he had done and be genuinely remorseful and withdraw from the plan, or he would become defensive and escalate. The first outcome was possible, but the first outcome would also mean that what had happened, the 3 weeks, the ghost, the manufactured narrative about my deteriorating mind, would be addressed without formal documentation, without accountability, without the intervention that might prevent it from happening to someone else. I had spent 40 years in the forensic application of psychology. I had testified in cases where elderly adults had been deprived of their autonomy through exactly the kind of manipulation Marcus and Claudia were attempting. I had seen what happened to those adults, the profound harm of having their reality systematically contested, the specific destruction of the trust between parent and child that the manipulation required. I was in this situation, not just my son's mother, I was also a person with the professional knowledge to recognize and document the harm. The formal record mattered beyond my individual situation. If the court found what the evidence showed, a deliberate attempt to have a competent adult declared incompetent for financial gain, the finding would create a legal record. Marcus and Claudia would be required to undergo psychological evaluation and, potentially, intervention. Future targets would be protected. I chose the full accountability. It was the right choice. It was not an easy one. The proceedings occupied 3 months. I will not describe them in exhaustive detail, because legal proceedings in contested guardianship matters are detailed and technical. And the detail is not the interesting part. The interesting part is what the evidence showed and how the court responded. Patricia filed the proactive declaration in the county court on the first Monday of March. The declaration was accompanied by the documentation, the field notebook, the physician's records, the listening log, and the selected audio recordings that were most directly relevant to the evidence of intentional manipulation. The declaration also included, as Exhibit A, my own curriculum vitae, 40 years of clinical and forensic psychology, which established my professional qualification to identify and document what I had observed. The Adult Protective Services complaint proceeded on a parallel track. APS interviewed me, reviewed the documentation I provided, and opened a formal investigation. They interviewed several of the neighbors and friends whom Marcus had visited with his narrative about my deterioration, and those neighbors and friends, some of whom were already uncomfortable about the original conversations, were forthcoming. Marcus and Claudia retained an attorney. Their attorney's initial response was to challenge the admissibility of the recordings, a reasonable legal strategy, but one that did not succeed in Michigan, where one-party consent makes such recordings clearly admissible. When the admissibility challenge failed, the attorney's response was to argue that the recordings had been taken out of context and that the statements captured were ambiguous. The ambiguity argument had some initial traction. The statements individually were indeed ambiguous. When we have the legal arrangement in place, could be argued to mean many things. The evaluation will show what it needs to show, could, with creative interpretation, be argued to mean that a genuine evaluation would show genuine cognitive impairment. What made the ambiguity argument fail was the context, specifically the 11 days of field notes that placed the statements in the pattern of the gaslighting campaign. The field notes showed that the statements were not isolated, ambiguous utterances, but part of a systematic behavior sequence, whose elements had each been documented on specific dates with specific details. The cumulative picture was not ambiguous. The judge in the proceeding was a woman named the Honorable Rosalind Whitfield, who had been on the bench for 12 years and who had the specific quality of judicial intelligence that I have always thought of as the most important kind. The intelligence that knows the difference between what has been proven and what has been asserted, and that requires proof rather than accepting assertion. She denied the guardianship petition, which, by the time the proceedings were underway, had been formally filed by Marcus and Claudia's attorney, because their attorney had apparently advised that withdrawing it would look worse than proceeding with it. She found that the evidence presented by the petitioners was insufficient to establish cognitive impairment at a level requiring guardianship, and further found that the pattern of behavior documented in the respondent's filing raised serious concerns about the petitioner's motives and methods. She ordered Marcus and Claudia to undergo psychological evaluation and to participate in a family counseling program under the court's supervision. She found that their behavior constituted elder abuse under Michigan statute, the systematic manipulation of an elderly adult for financial gain, and that the Adult Protective Services investigation had confirmed the finding. I sat in the courtroom, and I heard the decision with the equanimity of someone who has processed most of what she is going to process about the situation, and who has arrived at the specific piece of a decision well made. The psychological evaluation was completed by May. The evaluator, a colleague I knew professionally but had not referred the case to, which was important, found in Marcus the pattern I had expected to find. A man who was highly susceptible to influence from his primary attachment figure, who had had difficulty distinguishing his own motivations from those of the person to whom he had attached, and who had a history of gradually rationalizing behavior that he would have initially rejected when it was presented to him, incrementally rather than as a whole. In Claudia, the evaluation found something more specific, a pattern of interpersonal behavior that had characteristics consistent with a narcissistic personality organization, in which other people's autonomy and interests were perceived as obstacles to be managed rather than as primary goods. This is not a character assessment. It is a clinical one, and it is relevant to understanding why the guardianship plan had originated with Claudia rather than Marcus. People with this kind of personality organization do not experience their manipulation of others as manipulation. They experience it as intelligent management of a situation. The counseling program was 6 months. I do not know in detail what occurred in it. I was not party to it, which was appropriate. What I know from the court's subsequent reports, which are public record, is that Marcus completed the program and that the completion was assessed as genuine engagement rather than perfunctory compliance. Marcus came to see me in September, 3 months after the court's decision and 2 months into the counseling program. He called first and asked if he could come. I said yes. He sat across from me in the sitting room, the same chair he had sat in on the Tuesday of the ghost, the same room where the recorder had been on the shelf. The recorder was not running. There was nothing to document. What there was between us was the specific weight of something that had happened, and that was not yet processed, and that both of us were trying to approach. He said, "I want to say I'm sorry. I know that's not enough. But it's the beginning." I said, "Yes, it is the beginning." I didn't. He stopped. I knew. "I'm not going to tell you I didn't know what we were doing." I knew. "It's worse than not knowing." "Yes," I said. "It is worse." "Why didn't you say something?" he said. "When you knew, before the legal proceedings, you could have come to me." "I considered it," I said. "I chose not to." "Why?" I told him what I have described in this account. The professional consideration, the pattern that needed formal documentation, the people beyond me who might benefit from the formal record. He listened with the attention of someone who is genuinely listening rather than preparing a response. "You made it formal," he said, "because a private conversation between us wouldn't have prevented it from happening to someone else." "Yes," I said. He stopped. "That's very disciplined." "It was the right choice," I said. "It was also difficult." He was quiet for a moment. Then, the recorder. "When I came that Tuesday, were you performing the confusion?" "Yes." I said, "You were performing the confusion that we were trying to create," he said. "Yes. To give us the opportunity to say what we were planning," he said. "Yes," I said. "The questions I asked that evening were designed to invite elaboration. I was not telling you what to say. I was asking questions that made the most salient thing in your thinking, the thing most likely to come out. What came out was what you were thinking." He looked at his hands. "The counseling program," he said. They describe what I did as, they describe a pattern. That I'm susceptible to a specific kind of influence. That I allowed myself to be moved into things. "Yes," I said. "That is consistent with what I observed across your life." "You knew about this," he said, "about me, before any of this." "Yes," I said. "And you didn't. You were not my patient," I said. "You were my son." There is a distinction between the professional role and the parental one, and I have tried to respect that distinction across your life. Observing something about my son is not the same as intervening therapeutically, and the appropriate form of the parental relationship is not clinical. He thought about this. "Do you think you should have said something?" "At some point. Before this. I have thought about this," I said. "I think the answer is yes and no. I think the right moment for the specific conversation we needed to have was a moment I did not find. That is a failure of the parental role. I also think that the appropriate conversation could only have happened in a context of genuine readiness to receive it, which you did not have before the counseling program produced that readiness. And now, he said. Now you are ready, I said, and we are having the conversation. The house in Ann Arbor has always been a house that works. Not in the decorator's sense. Samuel and I were not people who thought much about how a room looked in the way of people, for whom the looking is the point. We were people who thought about how a room functioned, and the house functioned well. It had the kitchen I needed, the study I needed, the garden that became Samuel's primary occupation in the years of his retirement, and that I have maintained since his death with less botanical precision and more botanical affection. After September, after Marcus's visit and the conversation, and the beginning of what I thought of, cautiously, as the possibility of a relationship different from the one that the preceding 18 months had produced. The house had a specific quality that it had not had since before the 3 weeks of the manipulation campaign. It had the quality of being simply what it was, a house where an elderly woman lived and worked and gardened and had visitors and was at home. Not a house that was being contested, not a house that was under observation by people with plans for it, not a house that required me to be vigilant about what was happening in it and who was doing what. The vigilance had been appropriate and necessary, and the appropriateness of it did not retroactively make it comfortable. 40 years of professional vigilance, the clinician's constant attention to what is being said versus what is meant, to what is being shown versus what is true, does not require effort in the way that vigilance does for most people. But it is its own kind of presence, and the absence of it in the house in October was its own kind of rest. Patricia and Becky had prepared a revised estate plan, which I had been meaning to do for 2 years, and which the events of the spring had made urgent. The estate plan directed the house and the financial assets to the charitable foundations that I had been supporting since the early years of my career. The Psychology Scholarship Fund at the University of Michigan, the Elder Advocacy Organization in Detroit that I had been a board member of for 15 years, and a smaller bequest to a community mental health clinic on the east side of Ann Arbor that does work I consider important. Marcus was not in the estate plan. I had thought carefully about this in the month before I finalized the plan, and I had arrived at the conclusion that the appropriate response to what had happened was not to punish Marcus financially. The guardianship petition had not succeeded, and the house was mine and not his, and there was nothing to restore that had been taken. But to be honest in the estate plan about where I believed the assets should go. I had told Marcus about this. Not in the September conversation, it was too early then, but in November, when he came again and when the conversation was different in quality from the September one, which was the quality of conversations that have had a month to develop from the first exchange, he said, "I understand." He said it without the performance of understanding, which is the specific quality that tells me when understanding is real. I didn't come back to inherit. I came back because I want a different relationship with you. If that's possible. It is possible, I said. It is what I want also. Whether we achieve it will depend on the kind of patience that neither of us has had easy access to. Yours or mine, he said. Both, I said. Mine because patience with the people we love is harder than professional patience. And yours because what you need to build is not something that can be built quickly. He nodded. He stayed for dinner. Yours. It is December now. The house is as it is in December. The garden dormant, the study full of the papers and books of a working academic who has not stopped working because she retired and who is currently writing what she expects will be the final book, a book about what psychology knows and does not know about the experience of aging. The recorder is in a drawer. It does not need to be on the bookshelf anymore. Marcus comes for dinner once a month. The dinners are not what the dinners before 2022 were, not the performance of family that the preceding years had been. The warmth organized around the plan. They are something more tentative and more real, the dinners of a mother and a son who are building something from a place they did not intend to reach, and who are doing the building with the specific care of people who know that what they are building is fragile. Claudia is not part of this. I do not know what will happen with Marcus's marriage. That is not my situation and not my assessment to make. What I know is that Claudia has completed the counseling program and that the evaluation made specific recommendations that she has, by Marcus's account, engaged with seriously. What that engagement will produce in her and in the marriage is not mine to predict. What do I know at 74? After 40 years of studying what happens inside people and between people and what the field notes and the recordings and the court proceedings and the September conversation and the November dinner have taught me, I know that the most sophisticated form of psychological knowledge is the knowledge of your own limitations. I have spent 40 years studying perception and memory and the ways in which reality is constructed and manipulated. And the most important thing that 40 years of that study has taught me is that I am as susceptible as anyone to the distortions that human perception is capable of, and that the protections against those distortions, the documentation, the recordings, the professional distance from the situation, are not protections against susceptibility, but protections against the consequences of susceptibility. I know that gaslighting is effective not because it is subtle, but because it exploits the specific vulnerability of people who love the people who are doing it to them. The specific disorientation I felt in the 3 weeks. The moments when the manufactured uncertainty penetrated, despite my knowing that it was manufactured, was the disorientation of someone who loves her son and who does not want to believe what the evidence is showing her. The professional knowledge did not prevent the emotional response. It gave me the tools to document what I was experiencing accurately enough that the documentation would be useful. I know that the right response to someone trying to manipulate your perception of reality is not to confront the manipulation directly. Confrontation gives the manipulator the opportunity to manage the confrontation, but to create conditions in which the truth of what is happening can be observed and documented accurately. The recorder was not a weapon. It was a witness. I know that the people who do harmful things are rarely simply villains, and that understanding how someone came to do a harmful thing is not the same as excusing the harm. Marcus was susceptible. Claudia was manipulative. Both things are true. Both people are responsible for what they did. Both people are, within the limits of what I can observe, engaging with that responsibility. And I know this last thing, which I want to say plainly, that the house in December, with the garden dormant, and the study full of papers and the recorder in the drawer, is mine. It has always been mine. The 3 weeks of manipulation and the Tuesday ghost and the court proceedings and the September conversation did not change whose house it is. What they changed was the clarity with which I understand that fact, and the documentation that exists if the fact is ever again disputed. My name is Dr. Vivian Grace Okafor Sterling. I am 74 years old. I spent 40 years studying what happens inside people's minds and between people's minds when the truth is not being told. The recorder documented what happened in my sitting room. The court found what the evidence showed. My son is coming for dinner in December. I am in my house. It is good to be in my house.